Good morning. I'm Judge Ryan Sullivan. I'm going to be handling the hearings today. Before we start, counsel, are there any requests on people you'd like to have heard early on in the docket today?
Good morning, Your Honor. Hunter Heydrich for the state. I don't have any special requests for cases I want heard early. I don't believe we will have any victims present. We do, I believe, have a joint request for a continuance, Mr. Javier Martin said.
That is correct.
All right, I'm just going to go down the list. Let's begin with Darius Luster for a bail hearing.
In speaking with Mr. Luster, he's not present today, but I would ask to waive his appearance and move forward with the bail hearing.
All right. Like we continued this for victim contact. Let's begin the bail hearing with the state.
Thank you, Your Honor. In this case, the state is seeking bail in the amount of $40,000 bondable with no 10% cash option. As noted, Your Honor, we have attempted to contact the victim in this case. We, after 2 days, have not received any return phone calls. So in moving forward with the bail hearing, we are requesting that there be a no contact order pursuant to court order, a no firearms or weapons clause, as this is a crime of violence, and DAS or pretrial supervision with testing for drugs and alcohol. Mr. Luster scores a 13 on the risk assessment, noting 2 points for failure to appears and 1 point for a prior felony conviction or gross misdemeanor conviction. I do believe that that should be a 2, however, as there are based on his criminal history. In 2025, this year, he has been arrested on a failure to appear and convicted out of this court on drug paraphernalia charges, trespassing charges, and he also had a drug paraphernalia arrest out of the Reno Municipal Court and that he failed to appear on, and another failure to appear arrest on a trespassing case that ended in a conviction. Last year, he had another failure to appear arrest and a gross misdemeanor conviction for taking a vehicle without owner's consent. That case lists 4 prior felony convictions, the most recent of which was in 2021 for a felony conspiracy to violate the U.S. Controlled Substance Act. That is out of Las Vegas. He had 4 misdemeanor convictions for drugs not for interstate commerce out of Las Vegas between 2021 and 2019. In 2019, he had an arrest for a parole violation, a 2018 felony conviction for attempted possession of stolen property, and a 2015 felony conviction for attempted possession of stolen motor vehicle. Given that history and the facts of this case, Your Honor, we do believe bail to be appropriate and the least restrictive means to ensure the safety of the community. And given the significant number of failure to appears, Mr. Luster's attendance at court.
Thank you. For the defense.
Judge, at this time, we're seeking a lesser amount in bail to the effect of $10,000 bondable with a 10% cash option. While Mr. Luster scores a 13 on the MPRA, I do think that justifies some level of monetary bail. I'm basing our request on the factual allegations of this case and the depth of physical violence purportedly used. It appeared to be just a singular push. It wasn't a punch. It wasn't a repeat act of violence. So I think that is somewhat mitigating. And then looking at his criminal history and based on the state's recitation of Mr. Luster's prior activities, it appears that his conduct is primarily drug-based and or theft-related. It isn't usually something that involves violence. That's also reflected in his MPRA score. And I think that makes this type of conduct, in some sense, an outlier from his usual activity. And I'm just seeking a bail amount that reflects both of what I've just argued. And so I think 10,000 bondable would be more appropriate. And with that, defense will submit.
The violence here certainly wasn't extreme, but it is still a violent allegation. I'm concerned about him failing to appear for multiple court dates, and he has a significant criminal history. So for those reasons, monetary bail is necessary. I'll set it at $20,000 bondable only. No contact with Haley Goff. He'll be supervised by pretrial services, no weapons, and tested for drugs and alcohol if he posts. I have a bail hearing for James Neufeld. Good morning.
Morning.
This was also continued for victim contact. Let's begin with state.
Thank you, Your Honor. So similarly, we have been unable to get a hold of the victim in this case. We did attempt to contact her again this morning and left her a voice message. Your Honor, most concerning to the state, however, is in reviewing Mr. Newfield's jail phone calls, he has contacted the victim in excess of 30 separate times. Based on the nature of those calls, I do anticipate more charges to likely file for dissuading a victim. The highlights of which are Mr. Newfield indicating that there is a no face, no case, that he advised the victim that even if she is subpoenaed, she does not have to show up. Other instances of domestic violence where the victim doesn't show up are dismissed. And that he does go into a series of victim blaming, indicating that the only reason he is here is based on her calling the police. Your Honor, given that and Mr. Newfield's risk score of a 7, as well as his criminal history, the violence in this case, we do believe bail is appropriate. We'd ask for $40,000 bondable, pretrial or DAS supervision, no firearms, no weapons, no contact with the named victim. Given the phone calls, Your Honor, we are asking that no contact order be pursuant to order and pursuant to statute. Regarding Mr. Newfield's criminal history, in 2019, he had a failure to appear arrest and a probation violation with no disposition after being convicted of felony possession of a controlled substance here locally. In 2018, he had a felony conviction for attempted grand larceny. In 2017, he had a gross misdemeanor conviction for conspiracy to commit carrying a concealed weapon. 2014, he had 2 misdemeanor convictions for destruction of property, 2 misdemeanor convictions for assault, and a misdemeanor conviction for threats to person or property, as well as a misdemeanor conviction for criminal extortion in threats or person to property out of Colorado. And then in 2013, he had 2 more trespassing convictions out of this court. So, Your Honor, as noted, concerning that he is attempting to dissuade the victim from participating in this case, and given that we do believe he presents an ongoing risk to this victim, and bail to be the least restrictive means with the noted conditions.
For the defense.
Yes, at this time, we're seeking an OR release with appropriate release conditions. I think what's important to note is that he only scores a 7 on the MPRA. That puts him as a moderate, not a high risk. I think within that, I would guess I would seek the court to turn its attention to the factual allegations of the case. What stuck out to me was the way in which the alleged victim was purporting how she knew that my client was intentionally trying to hit her with a vehicle, basically premised it on because the vehicle is so old. She knew that the way in which it was turned a certain type of way, that's how she knew there was criminal intent behind his conduct. I think that also points to the alternative, which is because this vehicle is so old, he is trying to leave the area with said vehicle. And because the vehicle is so old, the turning radius is not good enough. And so that could, potentially show or make someone believe that they are almost getting rammed with the vehicle. But I think that could also just be the result of how old and how poor condition this vehicle was in at the time of this alleged incident. As for the allegations from the state pertaining to potential dissuasion of the witness, can't really speak to any of that just because we don't have those phone calls, but I believe our office is looking forward to receiving those phone calls to see if there's any validity to those allegations. I think all the same, Mr. Holloway can potentially be, Mr. Neufeld can potentially be safely supervised in the community without any further danger or harm to other people. He has represented to our office that he does have a different place to stay if afforded an opportunity. And so I think a no contact order could be navigatable for Mr. Neufeld. He would be able to live elsewhere, and currently he's looking for work, but has yet to find a steady job so far. But all the same, he's trying to get himself back on his feet and have a better bearing in our community on pretrial supervision. So with that, defense will submit.
Thank you. How the evidence supports that Mr. Neufeld was certainly driving the motorhome in a seriously reckless, if not criminal way. Ms. Holloway indicated it lunged towards her. She had to dive towards the passenger side. Then it hit another vehicle. I see that it also hit a planter box. And the reason why the motorhome was in this area is because Ms. Holloway's son is basically on life support at Renown. So I'm very concerned with how the details in this probable cause play out. I do see that he scores a moderate, but I believe that monetary bail is necessary given the criminal history and the allegations. I'll set it at $15,000. It's bondable only. Absolutely no contact with Jimmy Holloway, sir. They've already recorded and listened to all your phone calls you've made to her. If you do it again, they'll just have more evidence because it's pursuant to statute, NRS 1784845 for 120 days. That means that you can be prosecuted for a totally separate offense in addition to this one if you break that no contact order. So you cannot call her from the jail, and you'll have no weapons and supervised by pretrial services if he posts a bond. Thank you.
All right. Back.
Next, we have a first appearance for Kevin Boughton. Good morning. Probable cause has been found. Public defenders appointed. Let's begin the bail hearing with the state. You're muted, Mr. Heydrich.
My apologies, Your Honor. If I could just have one moment. I just received a note from my investigator regarding victim contact.
Of course.
Your Honor, in this case, the victim is not seeking a no contact order. They did want to provide to the court that this, from her perspective, was a big misunderstanding and that the victim had been drinking that night and fell, which I believe is also reflected in the probable cause sheet in her statements to law enforcement. Your Honor, given the victim's representations, the state is not going to seek bail for Mr. Boughton. We would ask for pretrial supervision, a no firearms or weapons clause, and given the victim's wishes, no contact order be issued. Mr. Boughton scores low on the risk assessment and a 3 and has no prior documented criminal history, so we do believe there are least restricted.
So, Mr. Boughton, I'm going to release you. However, if I hear that you're arrested again for any kind of aggression towards people in our community, you will be immediately returned to the jail. Do you understand that?
Yes, ma'am.
And I'm not going to accept excuses such as people claiming they fell or hurt themselves or things like that. So you're to have no new arrests for any type of this behavior. And I'm giving you your next court date. And it's not up to the alleged victim whether this goes forward or not. It's up to the state. So you have to show up at this court date. It'll be January 14th at 9 a.m. Make sure you're here and don't get in any other trouble.
Yes, ma'am. Thank you.
Next, we have a first appearance for Roberto Gomez. Good morning. Probable cause has been found. The public defenders appointed. Let's begin the bail hearing with the state.
Thank you, Your Honor. Your Honor, in this case, the state is seeking bail in the amount of $75,000 bondable, pretrial supervision with testing for drugs and alcohol. While Mr. Gomez does score low on the risk assessment with a 4, the facts of this case are concerning a large quantity of numerous controlled substances and Mr. Gomez's criminal history. Most recently, he was convicted in 2022 of possession of controlled substance in CR 214563. The PSI in that case notes 9 prior felony convictions, 2 gross misdemeanor convictions, 6 misdemeanor convictions, and multiple prior failure to appears. Looking at that, in 2012, he was convicted of felony possession of a controlled substance with intent to sell and felon in possession of a firearm. In 2007, he had a felon in possession of a firearm conviction, possession of a controlled substance for sale, another case where he was convicted of felon in possession of a firearm, and another case where he was convicted of unlawful taking of a motor vehicle. In 2003, he had felony convictions for 2 counts of uttering, 1 count burglary, 1 count of attempted burglary, and then in 2000, a gross misdemeanor conspiracy to commit burglary. So given that history, Your Honor, I haven't looked exactly to see if he would qualify for habitual criminal enhancement, but it does appear that if he does not, he is very close. And with that ongoing criminal history, we do believe it presents a risk of flight and further criminal activity.
For the defense?
Yes, at this time, we're seeking bail in the amount of 5,000 bondable. I think that's in large part based on the MPRA scoring, the way in which he scored in that risk assessment, and the fact that we were able to verify some additional information. On that MPRA, he had no points for prior misdemeanors, prior violence, prior FTAs, has a verified residence, no multiple substance use arrests, and has a verified phone. I think by and large, that indicates he's not a flight risk. Now, for risk to the community, I understand that he does have certainly criminal history that involves several variations of convictions. All the same, in this present matter, we're just dealing with drugs. There is no allegations of theft or violence, which is good. There are no weapons present from my recollection of the probable cause sheet. And again, he would be able to live locally if afforded an opportunity at pretrial release. That's why I do think bail in itself is justified, but I think the bail setting should be something closer to about $5,000 bondable. I think that would be fair given the allegations in this case. Now, for pretrial supervision conditions, I think drug testing is appropriate, but I don't see a nexus for alcohol testing. A no weapons clause is also appropriate given his criminal history. And with that, defense will submit.
So his criminal history is extensive and involves many prior convictions, including one relatively recently for drugs and drug possession. However, I see that he scores alone was overridden to a moderate, so I'll take that into account when setting the monetary bail, as he also has failures to appear. As we said, at $20,000, that's bondable or 10% cash. He'll be tested for drugs and alcohol. He'll have no weapons, and he'll be supervised by pretrial services if he posts. Next, we have two matters for Andrew Thorne, a first appearance and a revocation hearing.
Go back, post that cash. The rest is on collateral. Okay.
Good morning.
Good morning.
On the new case, probable cause has been found, the public defender's been appointed, and on the older case, it looks like he's pending a sentencing date. Let's begin both matters with the state.
Thank you, Your Honor. Regarding case RCR 2025-133533, we are asking that Mr. Thorne's OR release be revoked in this case based on the new charges. Looks like the sentencing in that case is set for January 8th. We'd ask that bail be set in the amount of $10,000 bondable. Regarding the new arrest, we are seeking bail in the amount of $20,000 bondable, pretrial supervision, testing for drugs and alcohol. Actually, I think drugs is a stretch. I would just ask that the testing include for alcohol only, given that theft of here was alcohol. And we'd ask for a no contact order with Toro Bravo at 50 North Sierra Street. Mr. Thorne scores a 12 on the risk assessment. His criminal history is out of 5 separate states. He this year was convicted of misdemeanor resisting out of the municipal court. Looks like he has a bench warrant out of Story County and a failure to appear arrest this year. In 2023, he had 6 arrests for out of jurisdiction warrants out of Colorado, as well as a failure to appear arrest. He has a misdemeanor vehicle theft conviction and a felony out of Colorado, and then a felony burglary conviction of Oregon. In 2022, he had misdemeanor convictions for false reporting out of Colorado and an out of jurisdiction failure to appear warrant out of Colorado. Prior to that, looking at only felony or fugitive arrests, he had a 2021 felony burglary arrest that does look like it was pled to an attempted burglary, but later Mr. Thorne received relief in 2024. His criminal history notes arrest relief granted. He also had a misdemeanor conviction for trespassing, which was reduced from a home invasion and destruction of property locally. And then he also had a fugitive arrest out of Oregon. He has misdemeanor history going back, but those, again, are the highlights. So, Your Honor, we do believe monetary bail is appropriate. He was pending sentencing and under supervision in this case when he picked up these new charges.
For the defense?
Yes, so for the revocation matter, we will submit on the revocation and the monetary bail amount that the state is seeking. Our only addition is the same addition we're seeking for the bail hearing today, which is that he have an opportunity at direct transport to a treatment program. I think looking at his criminal history and also the factual allegations of this new case, it's quite clear that Mr. Thorne needs some help. He needs a structured environment with high intensity treatment. I think anything short of that is, setting himself up for failure. And I think the deprivation therein just means we're kicking the can down the road, so to speak. I think Mr. Thorne is in desperate need of said treatment. I know he is motivated to seek out said treatment. He just needs the right pathways. And I think that's best done with an evaluation done in custody and then with direct transport to a qualifying facility. So with that, defense will submit.
So both these cases are very similar, businesses being damaged, and he was just released about 10 days ago, and then this is happening. And I hear he also has a history of struggling with law enforcement, among other things. So I think there is a community risk. On the older case, I'm going to set bail at $5,000, bondable or 10% cash. All prior conditions will remain. His sentencing date will remain. On the newer matter, his bail will be $10,000, bondable or 10% cash, no contact with Toro Bravo, and supervision by pretrial services.
My apologies, Your Honor. Was that 10,000?
It was.
Thank you.
All right. Next we have a first appearance for Min Vu. Morning. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Thank you, Your Honor. Your Honor, we have been able to contact the victim in this case. He indicated he would not be attending this morning. He is seeking a no contact order. So given that, Your Honor, we are asking that a no contact order be issued in this case. He did express that he's not necessarily concerned with his own safety. His main concern is with the defendant's safety, given the facts of this case and attempted suicide. He does not want to have contact with her at this point, however. As noted, he did indicate that she does suffer from bipolar disorder, which is also reflected in the probable cause sheet. So, Your Honor, in this case, the state is not going to seek bail. Ms. Vu does score a 6 on the risk assessment and has no prior criminal history. She is a student at the university. We are asking that she be supervised by pretrial supervision. We are asking that she have a no firearms or weapons clause and that the no contact order be issued.
So, Ms. Vu, I'm going to release you. Mr. Merritt, do you know, are they both on the same lease for this apartment, or is it hers or his? Do you have any information about that?
I don't have any specific information about that.
All right, Ms. Vu, is this your apartment? Is this his apartment? Are you both on it as roommates?
We used to live before in his apartment, but we signed different lease, and he's going back to his home country forever. So, yeah.
Okay, so here's what I'm gonna do. You're not gonna have any contact with Muhammad Hussein Ali. So if he is at that apartment, you cannot be there, okay? But if he's not, if he's gone somewhere else, then I'll allow you to go back there. But you're not to have any contact. That means not by phone, not in person, not through social media. And given that this is her first offense, I think there are more mental health concerns than anything else. And hearing that the alleged victim may be leaving, I'm not going to impose any other conditions, but you have to show up at your next court date, Ms. Vu. That is going to be on January 14th at 9 a.m. Make sure you're here and do not have any contact with Muhammad Hussein Ali. Thank you.
And Your Honor, my apologies. Was there supervision or not? I couldn't.
No, not for this misdemeanor.
Thank you.
All right, next we have Javier
Your Honor,
Martinson.
My apologies. There was a gross misdemeanor attached as well. Prevent 911.
Oh, yes, no, I'm not concerned about that. Given the details and the probable cause.
Yes, Your Honor.
All right, so we're continuing Javier Martinson for everything, bail hearings, arraignments.
Yes, in speaking with some of the court staff, it sounds like there's also going to be an arraignment tied to the cases. So I would ask to set this actually for Monday as compared to tomorrow.
Why is that?
My understanding is on the weekends, we're only specifically supposed to be doing bail hearings, not additional hearings. So that was
We can do whatever the jail's willing to do. The jail was the one initially that wasn't willing to do them, but I heard that they are willing to do arraignments associated with warrants of arrest. So I'm happy to do it.
Yeah, I think that's understood and that's been communicated to me. I think all the same, I would prefer to have it set for Monday as compared to tomorrow.
All right, well, we'll bring him back then for all of his matters.
All right.
All right, counsel, anybody else that I missed or any questions or clarifications needed?
No, Your Honor, thank you.
Nothing from defense. Thank you.
All right, thank you. Have a good day.